Great, thank you. And thank you for everybody being here. Is anybody else planning on attending that we're aware of? Mr. Bateman, you had indicated that your client was here on the call. Are we waiting for anybody further?
No, excuse me. No, my client's on and we're good.
Perfect. Well, let's begin the meeting. Let's just make some quick introductions. We are a voluntary board here, and usually we have more than 3 members, but to move any matters forward or to make any decisions, we have to have 3 members here. And so the members that are present include Andrew Rennick, if you could raise your hand, and Wes Marriott, who just showed up, and then myself are the 3 members who are here as well. So we'll do the best we can for you here tonight. If there's a problem or if there's an issue that you don't like that happens tonight, there's always the possibility to appeal to the district court, and that the information on appealing to the district court is found in the packet that is put out by Provo City. But before we begin the meeting tonight, let me just say this. So there's a hybrid meeting protocol that needs to be read, especially for anybody listening or watching online. And it says this: for the past year, the Board of Adjustment has been meeting without an anchor location pursuant to Utah's Open and Public Meetings Act, and has instead conducted all meetings online. Notwithstanding the ongoing coronavirus pandemic and Utah County's moderate level of coronavirus transmission, the Provo City Board of Adjustments has determined to hold its meetings beginning May 20th, 2021 at an anchor location and online. Interested persons of the public can participate in the Community and Neighborhood Services Conference Room at the Community and Neighborhood Services Department with limited seating, or online by watching the live broadcasts at youtube.com/user/Provo Channel 17 and at www.facebook.com/Provo Channel 17. And with that being said, let's go ahead and jump right into the only item that we have on our agenda tonight, which is item number 1, which reads, Taylor Shaw requests an appeal of an alleged error to the Board of Adjustment for property located at 2813 South Sierra Vista Way in the Planned Industrial Commercial Zone, Spring Creek neighborhood. And just for the sake of allowing us how this will progress, we will allow Robert Mills, who's with us as well from Provo City, to make his presentation. After Robert is complete, the members of the board may have some questions specific for Robert, which we'll ask him. After Robert is completed, we'll turn the time over to the applicant or the applicant's attorney to make their presentation. And again, questions may arise after that presentation is made. And the questions may continue back and forth between Robert and the applicant as well. We'll then seek the input from the neighborhood chair if they're present. If not present, we'll then open the matter up for public comment. After public comment, the board will have further discussions and try to come to some conclusion at that point in time. So without further ado, Robert Mills, let's turn it over to you.
Thank you. And just to clarify, Marcus Draper from our legal department will be joining me with a presentation shortly after mine. So just want to make sure that we have time for him as well.
Thank you.
I'll give just kind of a brief perfunctory overview of what the request is and how we've arrived at this state. And then Marcus will give some additional detail as far as the letter that city staff wrote and answer any questions regarding that. So just some relevant history. All of this information was in the staff report, but I just wanted to highlight some things. So a business license was approved back in July of 2019 for this particular business to engage in cannabinoid oil processing and extraction. Shortly thereafter, in October 2019, an ordinance text amendment was approved by the Provo City Council that provided a definition for cannabis production establishment and removed cannabis production establishments as a permitted use in the PIC zone, which is where our applicants are located. And then after a January 2021 meeting with the applicant, city staff did send a letter determining that Blanc Holdings failed to meet a burden of establishing an existing non-conforming use based on a preponderance of the evidence. And then on March 16th, Mr. Bateman, the attorney for Blanc Holdings, filed an appeal for that decision. And so that's kind of where we're at now. So these are just some key issues that the Board of Adjustment is going to need to consider tonight. First, did city staff err in their determination that the applicant failed to meet its responsibility of establishing the existence of a non-conforming use by a preponderance of the evidence? And has the applicant actually established the existence of a non-conforming use by the preponderance of the evidence? So I'm not going to go over this slide in detail, but this is just both the Utah State Code and the Provo City Code that specifically places the burden of proof on the applicant for establishing the existence and proof of a non-conforming status. So these were the staff reasons for not granting the recognition of a non-conforming use that were delineated in the staff report and in staff's letter of March 2nd. First of all, Blanc Holdings has not processed any medical cannabis at 2813 Sierra Vista Way at any time. That's the applicant's business location. Number two, Blanc Holdings claim that its operation as an industrial hemp processing facility meets the definition of cannabis processing facility as it was defined by the version of Utah Code at the time lacks merit. And then number three, since Blanc Holdings does not possess the proper license from the state, it could not have legally operated as a cannabis processing facility prior to the zone change. And thus the claim for non-conforming status fails. The appellant reasons for granting the recognition of a non-conforming use also include three. And again, these are very perfunctory and summarization. So I hope that you've had a chance to review the staff report, review the individual letters and everything that was in there. So Blanc Holdings was engaging or intended to engage in the acquisition and possession of selling cannabis and cannabis-related products, which did render it a cannabis processing facility. Blanc Holdings must be categorized as a cannabis processing facility under the definition of Utah Code in effect at the time of licensure. And then Blanc Holdings state licensure as an industrial hemp processor is valid because it was granted under Chapter 41 of the Utah Code, of which 441A 201 is a part. So the Board of Adjustments does have a decision to make this evening. This is just straight from our code regarding the Board of Adjustment, basically stating that you may reverse or affirm wholly or partly. You can modify any requirements or decisions or determinations. It's important to note that there is a concurring vote of 3 members will be necessary to reverse any decision or determination. In this instance, there are only 3 of you here tonight. So if the decision was to reverse, it would have to be unanimous. And then as a courtesy, we at Provo City, we have always held the practice that if there are only 3 members of the board present, the applicant can request a continuance, and they have always been granted that as a matter of practice. You know, just based on their feelings of how things are going, they're welcome to express that desire. But regardless of whatever decision, we would just ask that the Board of Adjustment make findings on which they're making their decision. And that basically concludes my part. I will stop my share unless you have Any specific questions for me before we turn it over to Marcus Draper?
Does the board have any questions for Robert?
No question.
Just a quick question. Does the applicant have a state license now for the business?
They have a business license and they have licensure from the state.
Okay.
And I'll let the applicant specifically explain all of those details.
Okay.
Anything else? Okay. Marcus, you can take it away.
All right, thank you, Robert. Let me. Okay, let's see. That's good. Okay, I just want to clarify that last statement. My understanding is that Bonk Holdings has an industrial hemp processor license, but that is a license they hold from the state. So if Mr. Bate wants to clarify that, I'm happy to let him, but that's my understanding, just for clarification. Let's see. Okay. All right, so I think Robert kind of went over this. I'm just going to speed somewhat through this, but Provo City Code and states that Blanc Holdings bears the burden at this hearing to establish the existence of a non-conforming use, and they bear the burden of establishing an error was made when Mr. Larson determined that it failed to carry its burden in the initial determination. And Provo City Code defines non-conforming use one that was legally existing at the time when such use became prohibited due to a change in the code. So I won't read that verbatim, but that's the standard first that they have to meet. So I just wanted to clarify my understanding of the facts that were presented and as to what their argument is. And so I quoted one part of the argument because I do think it's a bit confusing unless you're have taken a deep dive into, I think, somewhat lengthy Medical Cannabis Act and just the overall kind of regulatory structure that the state has set up in regulating medical cannabis and its production. So Provo in no way disputes that Blanc Holdings received the license in the summer of 19. I think they filed their application on July 12th. I think it actually became effective in August of 19. I don't think that makes any difference to their application, but their application was to do cannabinoid, and I'm probably mispronouncing that, but let's see, backspace, oil extract. There was no mention of anything medically related at the time. They applied for their business license. Provo City Code business license requirements that they provided in the application that they provide a description of the business that they're doing, and that they keep that current with the city. So in order to lawfully be engaging in a use that requires a business license, such as extracting cannabinoid oil or producing medical cannabis, a party would have to comply with these requirements in this application and maintain that information updated with the city. So if they're doing CBD oil and that's what their application says, then that's to expand it beyond to something different like medical cannabis would require updating that business license information with the city in order to lawfully engage in that. The information, this is their application for a business license, specifically says cannabinoid oil processing and extraction. They also provided their articles of incorporation or certificate of organization of their limited liability company. And this may be hard to read, but it is in your packet, I believe on page 18. But it talks about the in Article 2, the purpose or purposes for which the company is organized to engage in manufacturing related to hemp. It doesn't say anything about marijuana. which hemp is limited to certain low levels of THC and nothing above that. There's nothing indicating medical cannabis, just those are the documents they provided. So the business license they received and allows them to do the industrial hemp oil, and they can continue to do that. It's always been continually our position that that's still a permitted use in their zone. It's just not a cannabis production establishment, which would allow them to manufacture medical cannabis, or in this case, process it. They've stated in their email with the city, and I pointed to one specifically on February 3rd, that has never done anything to date with medical marijuana, and that it was in the process of doing that, applying for a tier 1 processor license from the state, as they described in their email to Brandon Larson on January 8th. That's how they discovered the change in the zoning. So our understanding is that Blanc Holdings' claim rests entirely on its claim that by being an industrial hemp processor, that meets the definition of a cannabis processing facility, which is a type of cannabis production establishment. So this is a definition of cannabis production establishment. It's statutory. It's also in our city code. We've adopted the statutory definition, but they have rested their claim on being a cannabis processing facility right here. And they have, so to be a cannabis processing facility, this is again a statutory definition. And this has changed since 2019 and 2020, the state amended the code, but this was in effect at the time of the zone change. And this is the one that we're proceeding under. That they intend to acquire cannabis from a cannabis production establishment or a holder of an industrial hemp processor license. That they then possess that cannabis with an intent to manufacture a cannabis product. That they manufacture or intend to manufacture a cannabis product from unprocessed cannabis or cannabis extract, and that they sell or intend to sell to a medical cannabis pharmacy or research licensee. So in order to be a cannabis processing facility, they have to meet all 4 of these criteria, and it's our contention that they don't, because they are not acquiring cannabis from a cannabis production establishment with the intent to sell it to a pharmacy. They didn't have the proper license as to be a cannabis production establishment. You have to have a license from the state specifically for that purpose, as opposed to a license for the state as an industrial hemp processor. There's a different licensing scheme for both of those, and they are under different chapters in the code. They're both Title 4. They're both in Title 4 of the state code, but and one's in Chapter 41, one's in Chapter 41A. And I think there's a bit of dispute about that. But the Board of Adjustment, in determining the conforming use rights, in this case, I think is out of necessity needs to interpret the meaning of cannabis processing facility to make an accurate determination. And so I've attached some case law on how statutory interpretation is done. But the primary rule is that we're going after the intent of the legislature. And these are all Utah Supreme Court decisions. They're by no means unique. You can find these statements in very many decisions. These are just the ones that I chose to pluck them from. Discover that intent. The first, you look at the plain language. But when you're reading the plain language, and I'm referring to here Miller versus Weaver, you have to look at the statute as a whole and interpret its provisions with the provisions of other statutes in the same chapter and related chapters. You can't just look at it in isolation, but you have to look at it as it relates to other chapters. And one of the reasons they do that is to avoid any interpretation which would render parts of the statute or words in the statute inoperative or superfluous, and that they're trying to give effect to every word in the statute. And so this is where I think that Blanc Holdings runs afoul of the canons of statutory interpretation, because their interpretation of the definition of cannabis processing facility would render portions of the statute superfluous and lacking in meaning. One thing that was pointed out in Mr. Larson's decision was that in Title Chapter 41A, Section 201 of the Utah Code, it states, a person may not operate a cannabis production establishment without a license that the department, and that meaning the Department of Health, issues under this, or Department of Agriculture, issues under this chapter. Now, in their appeal, they, Blanc Holdings attempts to indicate that Chapter 41 is a part, 41A is a part of Chapter 41, but this is false. This is not correct. This is an incorrect interpretation of the law. The state of, so let's talk about that a little bit. So in Title 4, Chapter 41, Section 101 of the Utah Code, it states, this chapter is known as, Hemp and Cannabinoid Act. And in 441A, 101 states, this chapter is known as Cannabis Production Establishments. Now, if they were the same chapter, or 41A was a part of 41, these statements would be meaningless. Because how could 41A be a chapter? How could that chapter be known as Cannabis Production Establishments if it's not a separate chapter? Has been always the way I've understood that middle number is the chapter, and 41 is different from 41A. And you see this a lot in the Utah Code. You see it with titles as well, where you see, Title 63A through, I know, at least G, H. You see different parts, different chapters where you have A, B, and C. This is not uncommon for them to number it that way, but it's always understand that middle number represents the chapter. The first number is the title, the second number is the chapter, and the third number is the section. Is the position of Provo City that when the state code says a person may not operate a cannabis production establishment without a license that is that the department issues under this chapter, what that section of the code is saying is that you must receive a license pursuant to 4-41A. So a license pursuant to 4-41 is not sufficient to operate a cannabis production establishment. That being the case, this sentence would be completely meaningless if you're a cannabis processing facility and therefore a cannabis production establishment by virtue of having a license as an industrial hemp processor under Title 4, Chapter 41. So, we'd also like to point out that their interpretation of the statutory definition of cannabis processing facility has a separate defect as well. So it has 4 elements that one would need to establish in order to establish that they are in fact meet this definition. And the first one is in subsection A. You must acquire cannabis or intend to acquire it from a cannabis production establishment or an industrial hemp processor. That you then must possess the cannabis with a particular intent, in this case to manufacture a cannabis product. That you must manufacture or intend to manufacture the product from either or both unprocessed cannabis or cannabis extract. And that you must sell it to medical cannabis pharmacies or research licensees. So in order to be a cannabis processing facility, you have to meet all 4 of those things. One thing I would like to point out that's not in the presentation is that Provo City specifically requested that they provide a list of any of the medical pharmacies or research licensees that they intended to sell to, and none was ever provided. So I think that would be an independent grounds to find that they didn't meet their burden of establishing that they were a cannabis processing facility, because in order to be one, they must sell to a pharmacy or research licensee under subsection D. But I think there's an additional problem that I point to. If an industrial hemp, the holder of an industrial hemp processor license is a cannabis production establishment, then this bolded part is meaningless. So a person has to acquire or intend to acquire from either a cannabis production establishment or a holder of an industrial hemp processor license. But if the holder of an industrial hemp processor license is already a cannabis production establishment, it's completely superfluous. Which again, Monara's cited here, that you would need to seek to avoid any interpretation which renders parts or words in a statute inoperative or superfluous in order to give effect to every word of a statute. So you would not be giving effect to this bolded portion of the statute if a holder of an industrial hemp processor license was already a cannabis production establishment, because it would already be subsumed in the first part. So that is an independent problem that exists. There's been no evidence, and my understanding is that Blanc Holdings would not dispute that they do not hold a license under Title IV, Chapter 41A. That they hold an industrial hemp processor license. Thus, without the license under Title IV, Chapter 41A required to operate a cannabis production establishment, they could not have possibly been fully engaging in that use prior to the change in the zone. So for that reason, we feel that they have not met their burden of establishing that the existence of a non-conforming use by a preponderance of the evidence. There's no evidence that was presented that they hold the proper license, that they were engaging in that. All the evidence had to do with industrial hemp oil, having an industrial hemp processor license. And we agree that was occurred prior to the zone change, but we also would assert that the zone change didn't affect their ability, that it's still a permitted use. It's not a non-conforming use, it's conforming. And they can continue to do that, but what they can't do is operate as a cannabis production establishment, which would allow them to do different things than what my understanding they are presently doing. Thank you.
Thank you, Mr. Draper. Any questions for Mr. Draper currently?
So just a quick question on the 441A subsection. They're claiming in their assessment that since they're a holder of the industrial hemp processor license, they're categorized as a processing facility. You said that doesn't work for some reason, but that sentence is still in the code. So why is that sentence in the code if it doesn't apply to what they're?
Yeah, so let me point out to that what I think you're referencing. So let's okay, let's see. Okay, hold on. I'm not sure what's going on here. Okay, so I'll just leave it here. So if I understand you correctly, I'm going to clarify, and correct me if I'm wrong. So you're referencing this bolded part. You're muted.
Yes, that's the section. So you're saying it doesn't apply, but it's in code for a reason. So what is it defining? I'm
not saying it doesn't apply. I'm saying that the way they're misinterpreting it. So if you look at the grammatical structure of what this is, it says a person that A, acquires something or intends to acquire something, B, possesses something, C, manufactures or intends to manufacture something, or D, sells or intends to sell something. That's the grammatical structure of this definition. Now, if you look in subsection A, what are they acquiring or intending to acquire? The answer is cannabis. Okay, that's what they're acquiring or intended to acquire. And it says from, okay? That's telling you where they're acquiring or intending to acquire it. And it can be either a cannabis production establishment or a holder of an industrial hemp processor license. Those are the two locations from where you can acquire your cannabis in order to meet this definition. It doesn't say that
but it doesn't say, it says, I don't know if you're quoting it or not, but it says cannabis processing facility means, quote, and then that section, right? Or are you saying it doesn't mean that?
I'm saying So that quote is a direct quote from the statute that existed at the time. It has been since amended, so the language is slightly different. But this is the working definition that we're using because it was the one in effect at the time of the zone change. So a person that acquires or intends to acquire cannabis from either a cannabis production establishment, so this, or they acquire it from a holder of this. So a cannabis processing facility could acquire their hemp from Blanc Holdings. They could acquire their cannabis from Blanc Holdings. However, that doesn't make Blanc Holdings a cannabis facility. It just means that they could be a source for a cannabis processing facility to acquire their cannabis.
And
That's
they
what that
can't
means.
self-fulfill?
They can't what?
They can't, so meaning they can't serve themselves, basically?
That's not what that's saying. Well, they can't. They would have to get a cannabis production establishment license from the state, which they do not have. They have an industrial hemp processor license from the state. They don't have a cannabis production establishment license from the state. Their
And, but
contention.
this says industrial hemp processor license, which you just said they have. So
They do have that.
They
They
do
have that. I don't think you're understanding the argument I'm making. So I'm going to try to. So
That's
the
why
argument
I'm asking. I'm trying to understand how. So you're
Yeah, I
saying that the industrial hemp processing license. So a cannabis processing facility means a person that blank,
Yeah,
or a
that
holder of the hemp processing license.
No,
So
that is not. That's where you're, I think, running afoul of the what the statute is saying. The statute is saying that they have to acquire their cannabis from either a cannabis production establishment or an industrial hemp processor licensee.
Okay.
That's what it's saying. It's not saying an industrial hemp processor licensee meets A. It's saying industrial hemp processor licensee is someone from whom a cannabis processing facility could acquire their cannabis.
So meaning they could, but where I'm asking is they could technically acquire it from themselves.
If they had a cannabis processing facility license from the state, but they don't.
I thought you just said they did have one.
No, they have an industrial hemp processor license, not cannabis processing facility. I know it's a very complex, it's a really crazy regulatory scheme.
So basically it's saying acquires or intends to acquire cannabis from this or a holder of an industrial hemp processor license, which they have.
The from applies to both. That's where I think we're not seeing, where I think we're having a misunderstanding. You're interpreting this bolded part as if the from doesn't apply to it, but it does because they have to acquire it from somewhere.
Yeah, that's what I'm saying. They can acquire it from themselves. That's possible, right?
If they had a cannabis production establishment license from the state, but they don't.
But it says acquires from a holder of an industrial hemp processing license, which you said they have. So I'm just trying to understand.
Sure. So let me refer you back to the 441A 201. A person may not operate a cannabis production establishment without a license that the department issues under this chapter. And for the reasons that I explained, this chapter means 4-41A. Their license is not from 4-41A, it's from 4-41. So you can't operate a cannabis production establishment without a license under 441A. And there's several parts to that where it describes in part 2, it describes from 201 and on, it describes where, what you need to do to get a license under 441A. So they are manufacturing CBD oil, and they're doing that lawfully under 441. But 441A is what you need to manufacture medical cannabis, and they have that license.
I guess I'm just trying to understand the wording on it, because to me, you were saying that based on this, a cannabis processing facility means a person that acquires or intends to acquire cannabis from a holder of an industrial hemp processor license, which they have.
They have to acquire or intend to acquire cannabis from the holder of an industrial hemp processor license. They have to possess it with a certain. No, I understand. Right? I'm not disputing that they have that.
I'm just trying to clarify.
So where I don't think we're reaching a connection on, I guess, or maybe just rejecting my argument, I don't know, but where I don't think we're reaching a connection on is that, yes, they could acquire it, I guess, theoretically from themselves to meet A. The problem is they can't do that as a cannabis processing facility unless they get a cannabis production establishment license from the state, which they did not get. They do not have, and they, to date, to my understanding, do not have a license because the zone changed and the state wouldn't give it to them. So they could not, without that license, they can't acquire it from themselves lawfully as a cannabis processing facility because they don't have the licensure necessary to be a cannabis processing facility.
Yeah, to me it's circular, because if it means cannabis processing facility is that, then they are a cannabis processing facility, right? But that's how I'm visualizing it. But then they're not because they don't have the license or something.
No,
right?
they need A, C, and D to do it, and they need a license to do it lawfully, right? They don't have the license to do it lawfully. So regardless of whether or not they have to acquire their cannabis from somewhere. They aren't a cultivator. So ultimately they have to acquire it from somewhere.
Right. Okay.
Sorry,
I'm just trying to understand better, so I'm asking the questions.
That's fair, and I'm trying to answer them. I'm not trying to be confrontational. I'm just trying to make sure you understand my argument. I'm hoping you'll accept it. I do want you to make sure you understand it.
I appreciate that.
So what I guess ultimately, my argument is that if a cannabis production establishment, if an industrial hemp processor is by definition a cannabis production establishment, then adding this bolded part is meaningless because they've already said that you can acquire it from them. So that's, I guess, my response to that. That ultimately, yes, they have the processor license, but ultimately they get their cannabis from somewhere because they're not cultivators. And so where are they getting it from? In order to do that, they'd have to get it from somebody else because they're not growing it. They're not cultivators. So I guess a better answer to your question is no, they can't get it from themselves because they're not growing it.
Mr. Draper, just under this section, so I just want to make sure that I'm understanding this as well. Let's say we went and we said Provo City is wrong, and they are a cannabis processing facility tonight. When we agree to that, right? If we went down that road, are you saying that without the cannabis production license, they're still dead in the water?
Without a cannabis production establishment license from the state, you can't operate a cannabis processing facility because a cannabis processing facility is a type of cannabis production establishment.
Okay, and maybe this is a better question for the applicant, but your understanding is that they're dead in the water because they don't have on that application based on the actual zoning that exists, and they won't approve that because of the zone change.
That was my understanding, is that they either had to establish the non-conforming rights or they would not issue them the license. But I'm sure Mr. Bateman could clarify that issue.
Okay, one other question for you, Mr. Draper. I didn't hear an argument as to the intent side of things in regards to this chapter, to the screen that you have up right now. Specifically, I think they had argued in their letters and emails that they were taking this wait and see approach, right? That they wanted to wait and see what the market was going to do, but they had the intent to proceed forward with processing medical marijuana, if I'm not mistaken. I don't know if it was, I don't want to put words in anybody's mouth, but that was the idea. How do you respond to the idea or the question about that the statute allows for them to intend to do these type of things?
I think you have to read that with some sort of specific intent. Like they say we have some sort of general intent to do it. But this is all after it came to their attention that the zone had changed and that they were possibly being denied the opportunity to move in the medical cannabis field. But they never, when put to the task, who do you intend to sell it to? They never responded. They didn't have any customer lists. They just had some amorphous plans. And I don't think that that's what the state meant by intent. I think they meant some sort of real intent, that not some sort of like some plan to do it. Not, well, you know, we intend to do it at some point in the future. So, you know, if it's 10 years down the road, then, oh, well, we intended to do it 10 years ago, we formed that intent, and now we're doing it. But they didn't have any specific people that they had. They never provided the city with any information regarding, oh, what medical cannabis pharmacies or research licenses you're going to sell. That question was specifically put to them, and they never answered it. So I don't know how they can establish subsection D that they had the intent.
I just my follow up on that. Is there a, because that was my second question, and so I'm glad you're answering it. But is there some sort of timeline in your mind or in your understanding of when they have to prove that they intended something? Is there a timeline in any law or anything that has to prove that?
Yeah, they have to prove that they have to prove that they formed the intent prior to the zone change. And there's no evidence of that other than after the fact convenient statements. Oh yeah, we plan to do that. Well, who were you planning on selling to? Nothing. They didn't. No answer. So I mean, how can they prove that they intended to sell it to a medical cannabis pharmacy under subsection D with the only evidence being, oh yeah, we intended that? I think they need something more to prove by preponderance of the evidence. It's just not persuasive. It's a very convenient statement that you know, without something to back it up, it's just a convenient statement and nothing more, or some sort of amorphous intent. There are articles that they provided of their business organization said that they were going to manufacture hemp while reserving the right to do pretty much anything lawful, but you know, in their business license application, they said cannabinoid oil processing. In the business permits, which I believe application, and some emails regarding business permits, it was all CBD oil, hemp. There's no mention of anything regarding selling to medical cannabis pharmacies, research licensees, nothing of that nature. And so that combined with the fact that they didn't have a license to sell to medical cannabis pharmacies or research licensees, I think is very problematic for their position. They only discovered the zone change because they began to go through the licensing process to do that. And while they may have had some plans or some amorphous plans, there was no real specific plans. So I think that's a far cry from an intent to do something. When you just kind of amorphous plans that, yeah, we'll do that in the future. I think there needs to be something a lot more concrete than that.
Thank you, Mr. Draper. Any other questions for Mr. Draper? Well, we have him here for a minute. I'm sure he'll stick around.
I just wanted to clarify, a holder of a hemp processing license, are they permitted to possess cannabis?
They can possess cannabis. They can possess, you know, low level THC. They can process that. Yeah. So yeah, I mean, I guess they can possess cannabis, but for manufacturing CBD oil is my understanding, and that's very low level. Okay. Stop.
Any further questions for Mr. Draper? Okay, thank you. Why don't we turn the floor over to Mr. Bateman? I presume, are you going to be handling the argument, or a combination?
Yeah, we're going to use kind of a combination a little bit. And the reason for that is because the reason for that is there's a couple. First of all, a lot of this is factually dependent, and it requires understanding the science of what's happening here. That's important. And the only one in the room that's even close to a scientist is my client. And he'll be able to really clarify a lot of what is going on. And so I'm going to have him talk in just a second. And secondly, I just want to make sure that there are no prejudices here. You know, there are certain words sometimes that cause us to shut down. I had an appeal hearing not too long ago that talked about radiation in the context of making radionucleotides for cancer treatment. The fact that it said radiation caused some of the people to just shut down, assuming that radiation equated to Chernobyl. And we have the same situation here. You know, we talked about marijuana, we talked about cannabis, we talked about THC. I just want to make sure that we're understanding that this is not something that needs us to shut down. This is something that's legal and endorsed and medical. And we want to make sure that there's a clear understanding of what's happening here and what the objective here is before we get too deep into the legal arguments, which we will be brief about. But I do want to throw it to my client right now because I'd like for my client to just take a couple of minutes and briefly explain to us exactly what his business does and exactly what these definitions mean and the differences between hemp and cannabis and cannabinoids and things like that. So, Jared, if you want to pick it up and sort of give us a little bit of background, that would be really helpful.
Yeah, you bet. First, thank you all for being here. I know you're all very busy. I should be thanking you because I'm not having to mow the lawn tonight because that was on my list of things to do. But this is something that's become, I guess you could call it a passion project. So just a little quick bio about myself. I, went to school here in Provo at BYU, went to grad school over in London at London School of Economics and was in finance related things. I now manage a family office. And one of the investments that we had was we were approached as soon as the Farm Bill passed. You guys have seen CBD pop up all over the place. And it's because in 2018, they passed what they call the Farm Bill. And so I was approached because institutional investors don't touch THC yet. They will be, and they are starting to, but and I did a lot of due diligence on a bunch of hemp stuff, and I became a very strong believer in its therapeutic benefits. And that's where, in my due diligence, visiting Washington and Oregon and all over the country, analyzing these investments, it was how we stumbled into this. And now I'm, running this lab full time. So just very quickly, I'll lay out a very kind of high level understanding of how this works. Utah is it's the most unique market in the US when it comes to cannabinoids. That's how I say it. That's how the industry says it, cannabinoids. And the reason why is because just to very simply explain the difference between cannabis, cannabis is hemp and THC. It's the same. So cannabis is the parent of the plant, and what determines hemp or marijuana is levels of THC. That's it. So when you're above 0.3% THC, then you're marijuana, and when you're below 0.3%, you are hemp. So the reason why you're going to see, and I'm not an attorney. I have enough hats to wear as it is. I should have worn my white coat so you can see I'm in the lab quite a bit. But the reason why there's a lot of legal ambiguity here is because everyone's trying to figure it out. And in this case, as Brent will walk through, we have been always erring on the side of caution. In the hemp space, there's not a lot of ambiguity or gray space on the THC side. I'm not going to jail. The family I represent isn't going to jail. We don't mess around with any gray. And that's separated us. Now we're now producing cannabinoids, and that's part of our application to the city. Cannabinoids are the active cannabinoids in the hemp or in the cannabis plant. So you have, the ones you've heard: THC, CBD, CBC, CBG, CBDV, CBL, CBN. I mean, you name it, and we can manufacture those cannabinoids here in our facility. And that's what comes from the cannabis plant. Whether you get it from the marijuana side or the hemp side, it's all cannabinoids. And so we always intended to process cannabinoids because ultimately our real decision was, we know that all of this legal wrangling that is happening at state, it's going to go away eventually. It's going to be a federally legal thing, and which is fine. We were specifically approached by a number of cultivators because they saw a couple $1 million build out here, and they said, "We want you to be our processor. We want you to be our tier 1 processor." And so the key from our perspective, and the thing that's really important for us is we have a lot of relationships in this space. And if you guys are interested, I'm happy to. I'm close to a number of these cultivators. I have one of them here on my phone. His name is Blake Smith. So I'm FaceTiming him just so you guys can. I heard some arguments about my intent to acquire cannabis, but as I'm calling him, one thing that's very unique, and the reason why Utah is such a unique market is because Utah is the only state in the country that allows hemp-derived cannabinoids to make it into the medical market. And the reason why they do that is because there's cultivators here, and that's a lottery, and they were given a specific. They were allowed to. Oh, here's Blake. 1 second. Hey Blake, how are you? So one thing that came up. I'm going to flip you around here, or maybe do it like this. There you go. So this is
just 1 second, Richard. Would this be a better situation where he just calls into the Zoom so he can?
Oh, and that's fine too.
I don't know, and he could do it maybe in the public comments, or I don't know what you would prefer, Richard. But I just wanted to.
Well, it'd be much cleaner. It would maybe be a lot easier and better for the record, I'm presuming, if he could actually get on or click on the link. If you could send him the link.
Send him a link.
Yeah, that'd be great. Hey Blake, what's your phone number? And he's gonna just send you the link.
I actually get his email address.
Sorry, say it again. 801 what? 355.
Sorry, Jared. We need his email address.
I apologize. Blake, what email do you want it to go to?
Blake at zionmedicinal.com.
Blake at zionmedicinal.com.
We'll send him a link, and then when he comes on, we can have him join, and he can produce whatever evidence that you want from him. That's fine.
Very good. Okay, sounds good.
I'm sorry. What was the last part of that email? At Zion.
Zionmedicinal.com.
How do you spell medicinal? I'm trying to figure it out. Not that I'm sending the email.
Thanks, Wes.
MEDICINAL.
I put it in the chat for you, Crystal.
So what I was saying, and what Blake will explain as well, is if it's a thing of interest, is, and it's important, the only state in the country, and this was because we were a little bit later to the game and we could understand, Utah is very specifically saying we don't want people just to get high. We want these cannabinoids to be very specifically targeted for medicinal benefits. And so what the research isn't out yet because it's such an early, it's just been approved a couple of years ago, and THC at the federal level still isn't. And so there's not a lot of research, but there is, like, we work with an Israeli scientist who gives us very specific things about specific cannabinoids that target specific things: CBG, CBC, CBN, CBL. And so what Utah did is they said in between cultivators and pharmacies, there's what's called a tier 1 processor. And a tier 1 processor, the reason why they did that, and the reason why the code says that A part where it says industrial hemp processor, industrial hemp license holder, is because they want the cannabinoids that come from the hemp side to make it into the medical side. And so what that means is, as a tier 1 processor, you can take cannabis from a cultivator and then provide it to a pharmacy. Or what we've been doing is, because we can provide cannabinoids to all of the different tier 1 processors, ourself included, when we get that when we get that license, we have been providing cannabinoids to the medical market for a year and a half. And this is known by the community. This is known by the state. This is known by everybody. We're giving cannabinoids that are non-THC to the medical community to formulate and to give to patients, if that makes sense. So Utah's the only one in the country where you can be a tier 1 processor and sit in between a cultivator and a pharmacy and provide those cannabinoids into that marketplace, because we have the technology and the ability to provide those cannabinoids. One thing, Blake just texted me. I apologize. Oh, can you send it to Blake? He said his email he couldn't pull it up. Let me, I'll put it in the chat, if that's okay. So like in Blake's case, for example, he's an owner and the chief science officer for Zyme Pharmaceutical and Zyme cultivators. And they are one of the 8 licenses for the cultivation in the state of Utah. He is also a tier 1 processor, and he's working on getting his pharmacy license, or he hopes to get one shortly. Anyway, so that's the uniqueness of this. I think that what's happened largely here in the state of Utah is we've had a number of cultivators come to us and they've said, hey, we want to use your facility. We've had Wholesome Ag come, we've had Zions come, we've had True North come. We've had a number of these people come to our facility and say, we'd love to do this. And we didn't really know, so we've been intending to do it the whole time, but we were waiting to see when we would actually do it. Another thing that's, I think, very important to note is industrial hemp license holders also have the ability to handle what we call hot hemp. Now, what that means is anything above 0.3 is considered marijuana. Anything below 0.3 is hemp. Since we are so stringent about our protocols and our SOPs, we don't mess with anything coming in from out of state that's above 0.3. So we dilute all of our extraction, all of our extracted crude. We dilute it. I mean, it costs us way too much money to be compliant, because most people don't do this. But we get it compliant, ship it in, and then we work through the process that way. But in the state of Utah, we here in our facility, we have what's called hot hemp, or you could call it marijuana. And it's called hemp in process. The state knows this. They have an industrial hemp permit license to ship hot hemp from me, because when I create a distillate, it becomes between 2 and 6 or 7% THC. I ship that to a contract manufacturer, and then in final form, it gets down below the 0.3 when someone could take it. So it's a very gray area. For that reason, we only mess in black and white. We stay out of the black, we stay in the white, and that's why our lab is called Blanc Labs, because we always err on the side of caution. We did not, as you'll notice, as soon as we got our state industrial permit license with the state of Utah, and we had our business license with the city of Provo, only then, and Brent will show this, only then did we bring in all of our, hundreds and hundreds of pounds of crude oil that came in from out of state. And it was, of course, hemp compliant. And we have the Department of Ag transportation permit. But only then did we store it. And we stored it for 3 weeks before they changed the law. So we had every intent. And that's why I asked Blake to join, so he could, explain to you. We've known Blake for a very long time. And he is on the Zions cultivation side. And so I just wanted to have him just say that, explain what our conversations ever since he joined there, I guess 2 years ago.
Jared, can I take it from here?
Yeah, well, Blake's on. I don't want to take too much of his time, but since he's on, looks like he's driving, if we could have him talk for a minute just to explain. One of the concerns from one of the members of the board was, how did we know if they had intent? And Mr. Draper said they never responded. I must have missed that. I didn't know I needed to respond to that. But I just wanted to bring Blake on to explain that we did have the intent, and he was one of the people that we were planning on purchasing cannabis from once we got our license.
Good afternoon, everybody. So I'm Blake Smith with Zion Pharmaceuticals. We're one of the 8 cultivators for medical marijuana in the state of Utah. We are the only company to maximize our grow. We have 120,000 square feet. We focus very strongly on the medical side. We have very, very strong reservations against anything other than medicinal cannabis. And so one of the hallmarks of us and our products and those we associate with is to produce anti-seizure medications that can remove inflammation, so it helps with arthritis. We currently have a study going with 150 cancer patients. You don't really probably need to know all the things that we're doing, but the point is we focus very strongly on medical. Because of that, we are very picky in who we are giving material to and want to make sure that it is based on being able to make medicines. Having known Blanc and the Hewish for a very long time, in fact, he'll tell you that we've helped set them up in many effective ways to help with the hemp side. So I myself have set up multiple facilities and have extracted millions of pounds of hemp myself. We have intentions and the ability to sell to them. And we are probably one of the only distributors who are able to have enough material to sell to those that we need to produce medicine.
Mr. Bateman, did you want to pick it up from here?
Do you guys need Blake anymore? I hate to keep him.
I'm happy to answer questions. If you guys need me for a couple minutes, I'm happy to explain anything going on in the programs, how the sales works, and anything that you guys need. I'm happy to have those conversations.
Okay, thanks. I don't have any questions. I think you answered some of my questions on that. So,
Blake, one question here. This is Rich Peterson. One of the questions was about intent and about whether Blanc actually had intent to move into the medical side of things, right? And I think the argument from Provo City is they didn't have that intent. How would you respond to that as of the time they got into business, coming forward to the present day?
Well, yeah, so that's a great question. So I'll try to keep it brief. So when we got approached to actually start the medical marijuana program, we were looking for partners very early on in order to help us extract and create medical products. Having known Jared for a long period of time, and they had already started a hemp company very early on. I would say this was easily a year and a half ago, maybe even a little bit longer. We started talking about what it would take in order for them to be able to spin up a medical marijuana side and have the necessary protocols and SOPs in place to be compliant with state law and being a processor for medical marijuana. And so from our side, at least what I can say from Zion, is the intent was that Blanc would be part of that process.
Thank you.
Yeah.
Any other questions for Mr. Smith before we release him? Okay. Mr. Bateman.
Thank you very much. Thank you, Blake.
Thank you.
As we go forward, questions, especially those that are more scientific, we can have my client pitch in. I just want to make some legal arguments and respond to some of the things that Mr. Draper said. I'm going to try to be brief, and I'm going to try to be efficient as I can and simple as I can, because I feel like that's what's needed here. So what we're here trying to decide is whether or not my client has a legal non-conforming use to get into the cannabinoid. I don't know how to say that business. That's why we have my client on. As Mark has pointed out, whether or not you're grandfathered depends on whether or not your use legally existed and was operating at the time the law was changed. Okay, that's critical because at the time the law was changed, at the time my client started operating, there was no difference in the statute between cannabis and hemp. There was nothing in Provo City Ordinance preventing them from doing what they were doing and what they were intending to do moving forward. The law changed in Provo, and at that point, after my client found out about it, it put a skid to their, put a stop to all of their processes. It put a stop to all of their plans. With regard to the license, Marcus is absolutely correct that you need a license to do this. Okay? The reason why we don't have a license is because the zoning changed. If we had grandfathering status, we could get the license. I submit, and this is impossible to prove, I admit, but because, you can't prove something that didn't really happen. But I submit that had the zoning not changed, we would have been able to get the license. And so it is a circular argument to say that they don't have a license, so they can't operate. If you look at the definitions of cannabis and hemp, especially as they existed at the time that my client started business, and at the time my client was moving forward with his business, was entering into a lease for his company, was obtaining materials, it was obtaining machines, was obtaining the lab processes necessary to go forward. At the time all that was happening, the definition of cannabis and hemp there was no distinction in the code. And to a certain extent, there still isn't. Now 401, we've talked about 441 and 441A. Those two are different, but that doesn't necessarily mean they're 100% independent. I'm not saying that one is subservient to the other. I'm saying that they're two parts of a puzzle piece, and they go together. Okay. If you look at section 441, and this has been discussed, so I won't spend too much time on it. It says industrial hemp means any part of a cannabis plant, whether growing or not, with a concentration of less than 3% tetrahydrocannabinol by weight. 0.3% is the key. If you look at the definition of cannabis in there, it also talks about something that's less than 0.3%. There just was not a distinction. The distinction was created later, after my client was going forward, after my client was operating and working forward in his business. Now we will admit that we were not producing cannabinoids at the time. We have not produced any cannabinoids. We
haven't produced THC from cannabis.
Thank you.
Marijuana cannabis. We make cannabinoids every day, all day.
Right. That admission, though, is not, the city relies on that heavily, right? That we have not actually produced. We can't produce. We don't have a license. We've intended to get the license. We intended to get the license before the zoning changed. And as I said, we should have been able to get the license. If we can get a legal non-conforming use status, we will be able to get the license by all indications here. Now, I just want to talk a little bit about something else that was brought up, and that's the plain language of the statute. I am a firm believer that statutes are to be read by their plain language, and the different parts of a statute are not to be disregarded, and so forth. Let's apply that here. Okay, let's apply the plain language to the definitions, and let's apply the plain language to the question of intent. Okay, Mr. Draper would like the word intent that, as you pointed out, appears again and again here, as far as, are you a processor? You intend to do this. You would like to add some kind of bar to that kind of, to what you have to overcome in order to actually show intent. He would like it to be some kind of proof or some kind of high level of intent. You have to have actually been moving forward. Plain language doesn't support that. The plain language says intent. That intent is there. We have evidence of the intent, and my client has just expressed that and shown you that evidence of the intent. The evidence was always, supports this, that the intent was always to get a license. My client might have taken different action if he'd have known that the zoning was going to change, that was going to prevent him from getting the license. My client might have, collected some evidence that maybe would have been stronger to show intent according to Marcus's definition. But that wasn't the case. You have to go back in time, and you have to look at the situation that was there at the time. At the time, he was starting a business. growing a business, always with the intent to do this, right? And he got his business license to go forward. There was nothing in the code saying that he had to do anything different than what he was doing as far as going forward. He had the intent to go and get that license. He was moving that forward. The zone changed. The question is he grandfathered? The question is, was he established and did it exist at the time the zone changed in a way that allows him to continue to go forward as a legal non-conforming use? And that's all we're asking for you to decide. There's a lot in the code now, that has been added and that's been changed that you can look at and you can say there's this distinction and that distinction. The city largely relies on the fact that he needs and doesn't have a license in order to do this. Utterly circular. He can't get a license because the city changed the zone. And so at this point, we're arguing that we're entitled to non-conforming use status so that we can go forward and we can have this excellent facility in the PIC zone in Provo.
And one thing I just might add is, I don't think that the city of Provo has been great. I don't think that even the staff and we disagree with what they've said, and obviously that's why we're here. When we had people come do inspections in their facility and they found out CBD, they were like, one of them was like, "Oh, I'm growing hemp." The other one was like, "Oh, I take it every day. I have social anxiety." And so it's a very the city's been great. And I don't think that what we do and what we would do would be to supply pharmacies to patients who have cards from doctors, medical providers. It's not like this would ever go any other way. We would never do recreational, for religious reasons. But we believe strongly in the medicine, and we think that our processes actually won't change when you're working with cannabis, hemp or marijuana. It's the same machines, it's the same system, and it would go right into the medical market. They expected at this time to have 14,000 patients. They have over 23,000. There is a very real need for sleep, for arthritis, for aches and pains, for seizures, for all these things. And so what we're really trying to do here is our capacity and our bandwidth could really help provide patients with the medicine that they're looking for. I just think that's important to keep in context. In the future, I don't even think the city code will designate cannabis as a drug as it does now. I mean, it would be, probably similar to, can you make Excedrin? Well, of course you can. Like it's not a big deal. So I digress, but I think that it's important to understand, if we become if you guys grant us that status, nothing will change from our perspective. It'll just allow our business to provide patients with the medicine that they need.
Thank you, Mr. Bateman, Mr. Ewish. Any questions for these two gentlemen from the board?
I think the biggest thing that I'm hoping someone can speak to, and maybe this is a question for later for Mr. Draper, but I guess I just want kind of that confirmation. There seems to be kind of I don't know if there's differing opinions or whether it's just been spoken to differently or I'm understanding it differently around this statement that Mr. Bateman has made, that the version of the statute that we are looking at does not differentiate, and therefore would allow us to read into those four categories or those four criteria a little more broadly.
I can respond to that initially, and then absolutely we should listen to what Marcus has to say about that. I think it's too strong to say that there's no differentiation. I think the two sections of the code, 441 and 441A, are talking about different things, but they're not defining things differently, right? And at the time in particular, but even now, it's really no different. The definitions in here cover both. You look at the definitions in 441 and section 02, it says Cannabinoid product means a chemical compound extracted from a hemp product that is processed into a medicinal dosage and contains less than 0.3% tetrahydrocannabinol by dry weight. And then it says industrial hemp means any part of a cannabis plant, where growing or not, a concentration of less than 0.3% tetrahydrocannabinol by weight. They're not defined differently there. This reflects some understanding that could be clarified in the statute, some understanding that they are really the same thing. It's a question of the volume of the THC oil, and the volume, and please correct me if I'm saying this wrong, Jared, the volume in both those definitions is the same, 0.3%. And so it does not really make a distinction.
Yeah, and the reason why it's saying that is because cannabis or hemp, it's by definition, by the legal definition that the city of Provo adopted from the state of Utah, is the same, which is cannabis. It's a cannabis processing facility. The way you read it, Wes, when you were going through it, and you're like, this seems so clear. It is, well, to me and to our side, it's so clear. We intended to do it. We were an industrial hemp processor license. I didn't even think twice about having to, do a zone change. And then when the third processor came and said, hey, we really looked into this and grower came and said, hey, we want to do this. They're like, oh, but they've changed the zoning. And I'm like, what are you talking about? And ever since then, I've been, I'm not fighting, everyone's cordial, but like, I've been trying to get this through, and that's why we're here. Because we disagreed fundamentally. We thought it was a misunderstanding of the law. And to be fair, it's been hard to, most people don't know what CBC is. In a couple of years, everyone will know, oh, that's for this, or CBG is for inflammation. It's a very young market, and it's changing, and people will get more educated, and the laws will then reflect it.
So, Jared, if I can ask this might be beating the same point, but I want to make sure that I'm really clear. Mr. Bateman made the statement, and if I'm quoting you wrong, please correct me, that the part of that definition was, refining these components into a medical grade product. And my understanding from what you're telling me is, yeah, we didn't, refine it into, a THC based or where THC plays a significant component to medical grade product. But we certainly did and continue to legally produce several things from cannabinoids that includes refining them to a medical grade product.
Absolutely. And I will tell you, keep this between all of us. We have provided 90% of the cannabinoids in the medical market from non-THC cannabinoids.
Other questions?
Other questions? I'm good.
Mr. Draper, I have a question back to you, if that's okay. Thank you for hanging around here too.
Sure.
Hearing now, specifically, you heard from Mr. Hewish, Mr. Bateman, and their witness who came in. I forgot his last name already. I apologize. About what their intent was, or what their intent is over the course of the lifetime of their business here. Does that change your opinion at all as to what they are or what they represent to be?
I think it's pretty clear what they are, what they want to be now. I don't think it establishes by preponderance of the evidence that prior to the zone change, even their witness said he didn't even begin conversations till a year and a half ago, maybe longer. That's not, a year and a half ago was after the zone change. So it doesn't really establish what they think it establishes. And he is a cultivator. So it wasn't even entirely clear that he said he works with doing it for medical reasons, but it was very, again, it never really answers the question of, do they intend to do they sell or intend to sell to medical cannabis pharmacies? And they've still never identified a single pharmacy to whom they've sold. or that they intended to sell at the time of the zone change, which is, I think, the appropriate question. So I do think that's problematic, that the evidence is, again, not sufficient. Another thing, again, I don't think you can be, I mean, I agree with Mr. Bateman with the statement that, yeah, we're here to find out whether or not they have a grandfathered non-conforming use. But I don't think that, but I don't interpret it the same way. The question is, were they engaging in the use prior to the change in the zone? Now, the question is, what is the use that they were engaging in prior to the change in the zone? And the only evidence so far that's been presented is the use was industrial hemp processing, which our opinion is they can still do and are still doing, and is completely permitted use within the zone. And we're happy to have them do it. There's no problems with that. But where we differ on the interpretation of the law is that they were not and could not have been engaging as a cannabis processing facility. And one thing I would note is that the cannabis is a defined term in the code, and it means marijuana, not hemp. It's defined. It is a defined term in the code. So I do want to make it clear. So I guess I differ somewhat with their interpretation of the evidence. The evidence was that we were taking a wait and see approach, and I guess at some point they contacted their witness with some purpose, but he's a cultivator, so they have to. I guess I don't see the evidence as being very clearly demonstrating that before October 13th, which is when the meeting was noticed up for what ultimately on October 29th, 2019, when there was a zone change, which prohibited cannabis production establishments in the planned industrial commercial zone, among other zones. That prior to that date, there's not evidence that they had that intent. Again, I don't think their witness really established that. He just said a year and a half ago, maybe later, maybe longer ago, we had a conversation, and that's kind of when our relationship began on this. And then Mr. Huish, and forgive me if I'm mispronouncing your name, testified that, yeah, they always had this intent, but there's no record documentation of it. It is somewhat self-serving, and I'm not accusing them of anything. I'm just saying it is what it is. There's no documentation of what their intent was at the time. It's only after the fact statement, this was our intent. And I know it's hard to get into somebody's head, but ultimately I think that the evidence is lacking on that. Furthermore,
is there a way we could pull up that city application again?
Which application? The business license?
Yeah.
Okay.
Why don't you finish your thought, Mr. Draper, too, and then we can let Mr. Ewish respond with that city application.
Sure. Again, they could not, in our opinion, lawfully have been engaged in as a cannabis processing facility because they didn't have the license, so they weren't engaging in the use. They may have had an intention to engage in the use, but they didn't apply for the license. You need a cannabis production establishment license from the state, and they don't have one. They still don't have one. So how could they possibly be engaged in that use even today, lawfully or unlawfully, without they need that license to engage in the use. So they may have been in preparation to engage in the use, but then the law changed. But ultimately, they didn't even apply for that license till much later, till long after, almost a year after, or about a year after the zone changed. And that's kind of what started these proceedings. So I understand
that. Why don't we let Mr. Ewish respond real quickly if you want to pull up that?
I'll pull up the document.
Yeah. So as we've kind of been educating everyone on what cannabis creates, cannabis has cannabinoids in it. So if you see here, it says cannabinoid oil, cannabinoids. It's the cannabinoids of the cannabis plant. So if you're looking for evidence, it's right there in the application. Cannabinoid oil processing and extraction. You can't even apply for the state license without local city ordinance or local zoning. So, back to what my attorney was saying, it's a circular argument. You can't apply for it without having the zoning. So
Why not, Mr. Ewish? Why not apply for the application or for the license when you applied for the original license? Or were you, I mean, is that the idea is that you were operating under the hemp license, thinking all was fine? Is that the idea?
Oh yeah, absolutely, 100%. You have to understand that at the time, you know, the city was getting ahead of, and I understand, like, I get it. My dad's the city manager of Sandy City. Like, I understand city planning, and I understand, like, all the arguments. I deal with, you know, planning commissions, and, you know, even last week, the city of Provo is understandably getting ahead of it. They don't want, you know, weed everywhere and, you know, these things. And so the idea was, hey, and this is what they talked about on October 29th when they approved it. And before on October 23rd, when the planning commission approved it, is they said, hey, we have to designate areas, or else the state will make it allowable to have cannabis processing facilities anywhere they want. So the city of Provo went and said, okay, let's find two zones that are very undesirable. They found an agricultural on the freeway, and they found a freeway industrial. I don't even know if there's any buildings there. And so they did that to say, hey, we have an avenue, and we got ahead of it. But I was already here. I already signed a 5-year lease. I'd already done my TIs. I'd already been storing hemp here, cannabinoid oil. You know, it was already in the works. And so, you know, and just last week, they permitted, you know, Desert Wellness, that's a marijuana dispensary, to do processing next to it. And in my conversation with the city, the staff of the planning department, they wanted to limit, you know, the places to put it. And I get that, like, that's fair. And so I was like, hey, can we do conditional use here? Can we do these other things? And you know, the staff was saying, well, we don't think we could support it. And anyways, it's unfortunate, but you know, this grandfather status would allow us to do what we need to do, and not give a blanket, you know, conditional use permit for a zone like the PIC zone, or for, you know, freeway commercial or whatever. So I understand why they're trying to limit the scope of who can do these things, and certainly doing a grandfather would do that in our case.
Thank you. Is there any other questions for Mr. Bateman, for Mr. Ewish, any others?
Yeah, Richard, do you mind if I respond to something that Mr. Draper said? Hi, I'm Taylor Shaw. I'm the other attorney for Jared Hewish.
Sure.
Yeah, he had just mentioned that there was no way to be a cannabis processing facility while having an industrial hemp license. However, if you look back at the statute 441 and what the definition of an industrial hemp license holder can do, it's almost synonymous with an industrial hemp processing license. And that's a large portion of our argument, is the statute was so new, so young, that really they were combining things. An industrial hemp processing license was almost synonymous with an industrial cannabis processing license. And as we showed, hemp and cannabis are the exact same thing, legally, how they're defined. And so if you actually read what it says in 441 at the time, it said that an industrial hemp license means a license to a person for the purpose of growing, cultivating, processing, or marketing industrial hemp or hemp products. We know that industrial hemp and hemp products are cannabis. Therefore, they're essentially saying the same thing that they did in 441A, which is you have to acquire, possess, manufacture, and then sell, right? I mean, those are other ways of saying that: growing, cultivating, processing, marketing. They're essentially, it almost feels like the laws are kind of so ambiguous that they really do coincide together. That as an industrial hemp processor, you are essentially a cannabis processor.
Thank you, Mr. Shaw. I appreciate it. Thank you for everybody's participation. Really do. What we're going to do now, without any further questions, I can't see on my screen any additional names, but if the neighborhood chair is here and wants to provide comment, Crystal, is that person present?
There is a little bit of a lag on YouTube and Facebook, so we'll wait a few seconds, but so far there isn't anyone who wants to make any sort of comment.
I would say that this would go toward the public comment as well. So not only just the neighborhood chair, but also for any members of the public. The instructions are on your screen.
There is no one waiting.
Thank you. With no public comments, we'll close the public comment period. And any discussion amongst the board based on the application?
Yeah, I have some thoughts. So I appreciate everyone's the back and forth and the different thoughts and opinions on everything. Like, I presented on both sides. So I just wanted to say that I know that there's disagreeing points. So just say everyone's done a good job. My thoughts on this are kind of falls. I own my own business, and running a business is wearing 20 different hats and doing a bunch of different things, right? And I personally believe that in every case of what is qualified as a cannabis processing facility, in every single subject, it says the word intent or intent. And as a business owner, there are many that I intend to do that I don't have a ton of proof to say that I intended it. Or if somebody said, hey, where do you want to sell your? Yeah, I'd love to sell Walmart. And then if they ask me for proof of that, I wouldn't be able to provide it. I'd just say that's an intent and goal, but I don't have it, right? Me, as it reads and for what it stands for, to cause for proof, for me, it is proof enough for them to say and to have the people that they do that they intended to do the things that the provision state. Is the important part. Just because they weren't able to do those things within the 3 months before the zone changed, doesn't mean that they didn't intend to do it at some point. And then to have the zone change and not be able to do it, it hurts them. It hurts the case because they didn't do it, and so they're like, oh, they must not have intended. No, they're trying to obey the law, and they're not breaking the law, and so they can't do something even if they intend to do it. Doesn't mean that they were actually doesn't mean that they couldn't do it. If the law allowed them, then they would, right? And so I just feel like the intent and the opportunity to it meets the criteria for me as proof that they could be defined as a cannabis processing facility. So that's kind of just my thought process as I was listening to a lot of that, but open to kind of discussing with you two on this.
Thanks, Wes. I think one of the concerns that I have is that along your argument there, Wes, in the intent side, is that there has to be evidence, right? There has to be the statute says by a preponderance of the evidence. So there has to be something to demonstrate what the intent was versus not having anything and other than a statement, right? There has to be evidence that goes along those lines in order to reach, at least in my opinion, in order to reach that preponderance of the evidence standard, right? Versus just saying, this is what I intended to do. It's hard to disprove that. However, with that being said, the things I wrote down was this. They intended to get a license, right? But they couldn't get the license because they were in the wrong zone, right? They were in talks with a producer. We received some evidence that they were going to be supplied, for a better word, marijuana plants or something, or oil of some, I don't know how that actually works, but they were going to receive something, and they were in talks with individuals to do that. They purchased the machines to process the cannabinoids. Jared, help me out here. Am I missing that?
Cannabinoids.
Cannabinoids. Sorry.
You'll get it.
Yeah. Sorry. they purchased the machines to do that. And from what I'm hearing on the testimony today is that it's no different to produce the higher than 3% or the medical grade or whatever you want to call it, that those machines can produce the same thing. They built out an entire facility in order to do this, and the process is going to remain the same in order to do that. So is there evidence of their intent to do something different or to do what they're currently doing? I think there's evidence to demonstrate that they were dealing in the hemp side or less than the 3% side. Do these additional ideas of evidence put them over the top and say, yeah, this is what we were going to do? I don't know the answer to that, other than it seems like any given business, any reasonable business is going to take small steps in ramping up to something bigger instead of jumping full-fledged into something and purchasing all this sort of all these ideas in order to get to that. And I think that was the testimony today. So I'm a little torn on that issue of whether it gets them over the top, but that's kind of where I'm at with it. So
and I think to your point that, like, when I'm talking about intent, I agree. I think that, like, the moment you buy a machine that can work with cannabis and you're spending a lot of money on that, that's intent. Like, you don't have to say what you're doing with it because it's for cannabis. Like, to me, that's my interpretation of intent. When I start a business, I don't say, oh, I can only do these 3 things. It's saying I'm buying a machine that can help me grow into the future. That includes cannabinoids, that includes cannabis, that includes hemp, that includes all the future. He's been saying the whole time, the future is going to change. The federal government's going to do this eventually. So we can talk about it now and, disregard it for 2 years and say, no, you can't do it. But in 3 years or 4 years, he'll just keep doing the hemp thing. And then when the government comes out with, yeah, you can do this, then it will open up for everyone, right? At that's what I'm saying, is that when you start a business, you intend to grow into the space. And that's why we're having this conversation. Like, if he didn't intend to do the cannabis at some point, we wouldn't even be in this meeting at this point, right? Like, the whole point is that he's intending to do it. And you can argue that, oh, he's only intending now, not when he started the business. But for me, why start a business when from what he said, is he's trying to grow into the cannabis space, the whole thing, right? So, like, why start a business when your only intent is to do one thing, when you can grow into lots of things, and the machine that you buy could grow into that? Like, if the cannabis machine can do cannabis, then I don't know. I can hear that, if that doesn't do it for people, but for me as a business person, I have lots of intent, and I may never do it, but because I have to grow step by step, but I don't have it documented. I don't have it, all these things, but I have an intent to grow my business, right? So that's why we're here, right? Because he has the intent to grow his business.
sure. Yeah, thanks, Wes. Andrew, what are your thoughts?
Yeah, so I'm open to the idea that what qualifies as intent is open to interpretation, and there certainly are, I think, to me, things that you can kind of hang your hat on for that. It's going to say, yeah, okay, so generally there may have been, or there's sufficient to say, whatever intent means, yeah, we could relax that and say, yeah, you meet it. I guess the question that I am thinking about then is there anything, if that bar is interpreted in favor of the applicant, does that fully clear the way?
Good question. I think they still have to go and get an application. They still have to go submit that to the state. I think this is the...
Oh, I meant fully clear the way as far as our decision tonight. Does it really hang on to whether or not we, grant, sufficient evidence for intent, or is that one of multiple pieces that we need to kind of consider? And maybe that's maybe something that even Mr. Draper could speak to, this kind of sense of I am if we as a board disagree with the harder line interpretation of intent that Mr. Draper presented, what hurdles remain to our decision tonight, or what other hurdles remain for the applicant, getting the outcome they're looking for tonight?
Yeah, basically we're just deciding, right? And my interpretation is we're deciding if it will receive the non-conforming, right? And based on that is whether they were going to do that or if they qualify as this processing facility. I don't know, Richard, if you have other thoughts on that.
Well, I think, Andrew, in answer to your question, I don't know the full answer other than to say the intent argument is just one argument of several that have been made, right? So the other argument that was made is, does this qualify under 41A or 41? And I just, for me, I'm not sure I want to get into that, and I'm not sure that would be helpful for us to try to analyze the difference between those two statutes. But that's another argument that one to me is not as persuasive, and that's why I've focused here today on the intent issue. The city says, at least in the packet here, the city says that Blanc Holdings has not processed any medical cannabis. And I think that we've heard that that's not true tonight. I think we've heard that they actually do process medical cannabis that's in the hemp side of things, or the 3% or below. And correct me if I'm wrong, both of you, but I think that's what we heard. So they were processing some sort of medical grade something that they were giving or they were providing, however they do that type of thing. So, and then the last issue was the last defense here was that Blanc Holdings did not possess the proper license from the state, and therefore it could not have legally operated as a cannabis processing facility prior to the zone change. Thus, the claim for legal non-conforming status fails. That's what Provo City argues as well. And at least on that one, I think they are accurate. They did not apply for, or they did not apply for a license, or I haven't seen any evidence of saying that there is a license that was requested, but they obviously do not have that license in order to process that at this point in time. So I think there's
maybe the both sides of that is they didn't do it in a timely manner, right? Like they applied for the first one, they got, they didn't apply 2.5 months later, Provo the law, so then that would make them ineligible to get the other one. And so in that timely manner, they weren't able to, but maybe if they'd done it 2 months before, then it would be fine or something like that. That's right. I think that's the counter argument, is that if they did it in a timely manner, we wouldn't even be here today, right? Like they would have got it, and then they would just, maybe, I guess, Pro might stop them, but then have the license, and then it would be a stronger argument for the Blanc Labs. But so that's the counter potential. But I think that at the time, I mean, it seems like for my information is that whether they, you can first do the cannabis side of things on the hemp and then wait and see what happens on the other side. And so let's pause and not apply for that license quite yet. And then 2 months later, Provo makes it impossible to get that license away. And we're in this balancing act there. But if they still have the intent, then in my opinion, then it still granted. And then Provo did accept and say they could have that license and later change. So,
does that help Andrew at all? I'm not sure that does. I'm just.
I mean, I think does. I mean, I guess part of me is also trying to figure out kind of the, the scope of our decision-making, power here. I mean, one thing that, to me, this does kind of sound, my read, it sounds like this is kind of a perverse kind of outcome of kind of like they've said, kind of a young, evolving legal process. I mean, whether, we hand, we, as if we have any power to do this, as it, Block Holdings gets a license tomorrow. I'm sure it's more complicated than flip a few switches. But ultimately, the point is really nothing really changes. It's not like, plants go up and all of a sudden, half the city is fumigated in THC and there's a bunch of junkies hanging out the back door, going through the garbage looking for, whatever they tossed out. Like, as far as the city's concerned, I know this is probably beyond what, we're considering, but there's nothing's going to change. If they don't get their license, as soon as I assume they're still going to produce what they produce, it's just not going to have THC content in it. And so,
basically, we're just opening the door for them to be able to get a license from the state by saying that they can non-conform and be grandfathered. So they would probably be a minority in that because of the timing of when they first applied for the license and was approved by Provo. So
sorry for cutting you off, Wes, but it's like it's like the Wild West. I don't know, you guys are probably laughing, at least the applicant's laughing, because I think it's absolutely true. And I think everybody here, including Provo City, goes through the ringer with the statute changes, with all these things that come down. And now everybody's like, oh, what do we do? What do we do? And they have to, and now it's jumping through this hoop and that hoop and all that sort of stuff, and trying to provide citizens and trying to provide businesses the opportunity to be able to do things that the state and what the legislature has asked, or the legislature has mandated that can be done. I mean, that's Wild West stuff, when it changes so quickly and so often as it does right now. I mean, it's that type of thing. So I don't know. For you guys out there, we are 3 citizens who try our best to make decisions. And as Andrew put it well, what power do we really have? Here we are. Provo City can appeal our decision. The applicant can appeal our decision, that type of thing, what we do here today. So with that, do we have any further comment from the board?
I don't necessarily have one, though. Robert, rules of, of the meeting, Jared has clearly been waving at us. Can we hear what he has to say?
We can definitely do that. If we open it to Jared, we'll allow Mr. Draper an opportunity to respond as well. So if you feel comfortable with that.
To me, I would like to have kind of one last shot, a lot's been said, a lot's been going around. I would like to kind of open that up just for, maybe those 2 comments, and then we can maybe move towards our decision.
That's fine.
If that's the case, could I pitch in my part before Jared does, and then we'll let Jared, if you want to indulge me in that?
If you can limit it, we'll give you guys 2 minutes each, because we've already been going for 2 hours. And again, we're at the Wild West. Normally we don't go this long, so
I'm going to be shorter than that.
All right.
I'm going to be shorter than that. I'm going to make 2 very short points. I do think the question of intent is what we're deciding here, because what we're deciding is whether or not my client was a cannabis production facility before the zone changed. If he was a cannabis production facility before the zone changed, then he gets to continue to be one. He's grandfathered as one, right? And the definition cannabis cultivation facility in the code, all 4 of those things talk about intent. Did he have the intent to do those things? And we disagree on what level of intent you have to show, but I do think that's what we're talking about here, is deciding whether or not he had the intent to do those things, and whether or not having the intent, which we really didn't know was going to be the focus here. So, but be that as it may, having that intent is enough. The second and final point I want to make is I want to make sure that the definition of preponderance of the evidence is being used accurately here. Preponderance of the evidence means the most evidence, the best evidence. And what we're talking about here is when we're talking about evidence of intent, whether or not there's more evidence of intent than there is evidence that there wasn't intent. And that's what a preponderance of the evidence is. And I really don't think there's any evidence that there wasn't intent. There is evidence of intent. That's all I have to say. Thank you so much for that little indulgence.
Thanks, Brent. The thing I was going to add is, the intent actually is important in this case because there was no pharmacies open at the time. There was no marijuana plants being grown at the time. This was a new program that had passed, over this, they were awarded, it was passed in legislative session in the spring. I think they even called it a special session because they wanted to change it from what was available. It is the Wild West. I mean, literally, they're going to call a special session in a couple weeks just to outlaw another cannabinoid. It's a psychoactive one, so they should, and we don't mess with it. But the intent is important because there was no pharmacies, there was no growing, there was no, and as Blake said, the owner of an operator of Zion's cultivars and Zion Pharmaceuticals is, or medicinal is, we were the first one, in the state to be set up to be able to do cannabis processing, and of course, similarly, same process for anything above 0.3%. So I think the intent is important. I think we've, proven that, that we certainly did in the investment that we put into it. I just brought you guys in here just to see this one piece of machinery because it's my favorite one. This is what refines the cannabinoids. And then of course over here we have all of our machines that help us refine all of the different cannabinoids. And then over here we, have a vac oven that takes out the solvents that we use to do that. So, our intent is all around me, and I really appreciate you guys' time. It is the Wild West. It's worth going through these issues. I'm very sensitive to the city's needs and desires. In a couple of years it won't matter, but this is what we have to do is go through the right process. We always do things black and white. We stay on the right side of it, and appreciate you guys' all of your time and listening to us.
Okay. I just would like to respond with a couple of quick points. Again, the evidence of it, there's no contemporary evidence of intent. It's all after the fact, a year and a half later, or 14 months, 15 months later, when they started the process with the city. That the evidence of intent all comes at that point. There's no contemporary evidence of what they intended at the time of the zone change or prior to the zone change. So again, is that credible evidence of intent to establish that they intended to sell to a medical cannabis pharmacy under subsection D, which is a requirement, or research licensee? We still haven't received any evidence of that. The second point I would make is I would say that Mr. Bateman was half right. We are here about establishing whether or not they were engaging in the use of operating a cannabis production establishment prior to the zone change. That's only half of it. They also have to show that they were lawfully doing so. In order to lawfully engage in that use, you need a cannabis production establishment license from the state, issued under the authority of Title IV, Chapter 41A, and they didn't have one, and to date still don't have one. And they could have obtained that prior to the zone change. They didn't, probably because they didn't know that a zone change was coming. But in any event, I think a lot of focus has been on whether or not this is a fair outcome, but your duty is to apply the facts to the law, and the law is that they weren't lawfully operating as a cannabis production establishment, even if they were operating as one, because they didn't have a license to do so prior to the zone change.
Thank you. Does any member of the board want to do anything, make a motion? And actually, before any motions are made, I want to give the applicant the opportunity to continue this hearing as was discussed by Mr. Mills early on, because there are only 3 of us here today.
Really appreciate that. We will ask this: if the question of the amount of evidence for intent is what's going to cause any of you to say no, if you would be courteous enough to let us know that, because we can bring back evidence of intent when we reconvene. If it's the amount of evidence of intent that's the problem, then I would ask for that and we can continue that. Otherwise, we really appreciate your time and your public service and your listening to us today.
Thank you.
I mean, I don't know what you guys are thinking as far as which direction you guys are going, but I'm kind of in the support the non-conforming camp, because of I believe that the intent has been satisfied, and by them buying the machines, creating a business, going through the cannabinoid. I mean, they're doing half of the business already that's legal. The intent to grow, the intent to sell medically is there through the evidence of their talking. The contemporary, I mean, we can't go back to that day when they set up the business and ask them what their intent was, but I'm sure they weren't writing it down or talking to specific individuals about deals. But I'm sure that, as you were saying, Richard, this is the Wild West. And when we're talking about medical cannabis 2 years ago, it was even more wild. And there was probably a lot of intent to get into the business and do the best they can in that way. And so for me, it meets the standard of that intent. And, that's kind of where I'm leaning. I'm leaning that to support the non-conforming or to reverse Provo's suggestion, but obviously we need all 3 of us to reverse that. So, but that's kind of where I'm standing.
Is that a motion, or do you want further discussion?
I mean, sure, let's do a motion.
Where I'm like, the intent thing is, I don't think is going to hold me up. And to Mr. Bateman's point, I certainly imagine that they could mount further evidence, and that's not necessarily something that I'm super concerned with. It's actually Mr. Draper's last point that I just want, that if anything's going to hold me up, it's this, is that strict interpretation, me taking off all the things that, that I think should happen, not having that license. I mean, it's that circular argument that we were kind of stuck in, right? If they didn't have the license, then they weren't doing it, so they can't start doing it now.
Right.
Where are you guys sitting on that?
Yeah, I mean, my thought is, if they, like Mr. Draper said, like, they probably didn't know the zone changing and the law was changing in Provo. Had they have known, maybe they would have done something different, which comes back to my intent thing, where they would have the license currently if they had this situation to be able to apply for it. But they got it, and then 2 months later, the law changed. Coming from my experience of starting a business, you're doing 50 things at once in the first few months, and you think you're all clear in the Wild West by getting a license in Provo saying, yep, you're good to go. And then 2 months later saying, no, you're not good to go if you don't have this license. I just think that if Provo agreed to it and they said, yes, you're good to go, but now you're not, but you can't get a license unless you're conforming. It's the circular argument, but I think that if they, the intent was to always get that license, in my opinion. So, maybe the timing wasn't great, but well, all we're saying is we're just stopping someone from doing business that maybe they can do business in a couple of years, but we're interpreting what their intent was with that business. And I think that if they'd known that the zone was changing, they would have jumped on that quicker and gone down that path, because again, we're in the Wild West and they are trying to do everything legally as they can, as the best as they can. So those are just kind of my thoughts on that.
I'll just follow up real quickly, Andrew, just for the sake of answering your question. The idea is, and Mr. Draper is accurate by saying that they have to demonstrate by preponderance of the evidence that it was lawfully engaged in the use prior to the code change. And I think, though, that needs to be added in there that they were lawfully engaging or intended to engage, right, in the business prior to the code being changed. I think that's the wording that should be in there. And again, that's why I'm so hung up on this intent issue. I shouldn't say hung up, but just concerned about this intent issue is because we're putting a business in this real corner or in this real box by saying, well, you had to do this, but you couldn't do it because we didn't allow you to do it, right? So again, it goes back to the circular concept. That's my thought on your issue.
I think I'm probably leaning towards I'm probably leaning towards the applicant's side on this one. I don't think it's open and shut. As a quasi judicial body, I feel like yep, a court would be better at interpreting the law. But from what I've seen as representing Joe Blow down the street, it makes enough sense to me.
Wes, you were going to make a motion?
Yeah, I was just going to make a motion. Help me with the wording here on this, Richard, but it's to overturn the city. Robert, maybe you can help me on this wording.
I think you're reversing their determination.
Yeah.
Okay, I make a motion to reverse the determination by the city based on our interpretation of the business's intent to do business legally in the city of Provo, and that they meet the criteria on what a cannabis processing facility means by the many examples of intent and actual work around that. So that's my motion to reverse that.
And are you granting non-conforming status?
And to grant non-conforming status.
Let me clarify that motion then and ask a question here, and maybe this is best for Gary McGinn or Robert. You could answer this question too, but
definitely for Gary McGinn.
Okay, well, is that sufficient facts in order for that motion to move forward? Is there sufficient facts by stating that?
I think so. If you by stating that you've determined that by a preponderance of the evidence presented in the hearing today, and the documentation submitted to you after reviewing all of those, that it's a reasonable and rational decision to come to.
Okay.
Thank you, Gary.
Can I just say, quote, Gary?
I would say if we can add to your motion, Wes, what the language that Gary just provided, I think will be sufficient with that.
Yeah, I should just do that on every time. Gary, you just make a statement and I'll just say, close quote, Gary.
Okay. We have a motion on the table. I will second the motion. Let's call for a vote on the motion. All in favor, say yes and raise your hand so we can see you.
Or do we just say our name since it's on Zoom?
That's fine.
So, yes, Wes Marriott.
Yes, Andrew Rennick.
And yes, Richard Peterson. Motion passes. Well, this has been a fun evening.
Really tempted to say we need a continuance, and one of the conditions was that Jared had to give me a tour of his facility.
Anytime, just let me know.
I will say this, we haven't had this much fun at the Board of Adjustments since we had to fight about a sign on University Avenue. So, I mean, this is like...
well, if you have trouble sleeping, I have some cannabinoids for you.
Richard,
go. Yes.
I think Robert mentioned this earlier. I just want to tell members of the commission and Brent and Jared, this is just housekeeping stuff for our next meeting. So you don't need to stay and listen, but you're welcome to. What we'll do is we'll still have the option for an electronic meeting, but we will send you in our notices at our next meeting that you can come here and have the meeting like we have in the past. We would just hold it in our conference room, and we would do our normal come in, have dinner a half hour before as a way of bribing you to serve on our board for free.
I've been telling Crystal she needs to send us some food so we can eat it on our Zoom call.
So you've been on that one too.
I've tried to email you a peanut butter sandwich, Wes, and it just hasn't. I'll keep trying.
Thank you, everyone, for being here and for being engaged in this process. Like, I think this has been a good discourse, and I appreciate everything that's gone into it.
So thank you all for this period, but now we can try to get back a little bit to normal. But yet still provide an opportunity if somebody's traveling or gets hung up at the office, they could still participate in the meeting electronically. So just be aware of that and look out for that in the future.
Awesome. Thanks, Gary.
With that, we will convene our meeting. Thanks, everybody, for being here, Provo City and the applicant as well. Appreciate it.
Thank you
Thanks,
all.
everyone.
Thank you.
Yes.
Bye.